I guess the question is, can these services bring lawyers and clients together to provide more legal work for lawyers that's meaningful to people who today wouldn't even consider hiring a lawyer? Perhaps they don't see their issue as legal, don't see a lawyer as a problem solver, or don't think they can afford it.
Welcome to the award-winning podcast, Lawyer to Lawyer, with J. Craig Williams and Robert Ambrogi, bringing you the latest legal news and observations with the leading experts in the legal profession. You're listening to Legal Talk Network.
Welcome to Lawyer on the Legal Talk Network. This is Bob Ambrogi coming to you from outside of Boston, Massachusetts, where I write a blog called Law Sites. Also host another Legal Talk Network program called Law Technology Now, along with Monica Bay. My co-host of this show, Craig Williams, is in court today and unable to be with us, so we're going to plod along without him. And before we introduce today's topic, I'd like to just take a moment to thank our sponsor, Clio. Clio's cloud-based practice management software makes it easy to manage your law firm from intake to invoice. Try it free at Clio.com. That's CLIO.com. Well, in 2016, the legal directory site Avvo launched something called Avvo Legal Services, a service that provides fixed-fee, limited-scope legal services through a network of attorneys. Ever since, the organized bar has been pretty sharply divided over the propriety, or the ethics, I guess, of lawyers' participation in the service and others like it. Several states in recent years have issued ethics opinions against the service. Last week, the Illinois Attorney Registration and Disciplinary Commission published a report that kind of goes against the grain insofar as it recommends that Illinois loosen its professional conduct rules, and I'll say loosen is my word, not theirs, and we can talk about that, but loosen its professional conduct rules to allow attorneys to participate in this and similar services. The report has now been published for comment and is not by any means a final action, but it's already been generating quite a bit of buzz. So today on Lawyer to Lawyer, we're going to talk about this report and talk with the author of the report. So let me bring him in now. I'd like to welcome to the program Jerome Jerry Larkin, who is the administrator of the Attorney Registration and Disciplinary Commission. Jerry is responsible for administering the agency, which registers Illinois lawyers and investigates and prosecutes allegations of ethical violations. He was licensed to practice law in 1978 and joined ARDC as staff counsel then. He's investigated, litigated, and appealed countless attorney disciplinary cases over the years. Later served as a senior chief counsel, assistant administrator, and deputy administrator before becoming administrator. Welcome to Lawyer, Jerry Larkin.
Thanks, Bob. I'm very happy to be with you today.
But Jerry, I want to kind of just start at the basics. I just kind of talked a little bit about what ARDC does, but tell us a little bit more about what the Attorney Registration Disciplinary Commission is and what it does.
Our organization is known by its acronym in this state, ARDC. I'd say in the last 10 to 15 years, we've focused a lot more on education and helping lawyers to serve clients better. So we investigate and prosecute. But we are not an integrated bar state. We are an agency of the Supreme Court of Illinois, and we have a board of governors, and all that may be helpful to understand our progress on studying this issue of matching services. We see it as a study. We've put out frameworks in the study. We have not recommended to anyone yet elucidating, to use your terminology, but indeed those concepts are all over the study itself.
Well, I want to talk a little bit more about all of that, but what was the genesis of this study? What started you looking at this issue and thinking about what led to your producing this report?
Well, it began at least 2 years ago, and it is responsive to our state's studies and concerns of the access to justice and access to legal systems issues, together with the employment situation for Illinois lawyers, particularly younger lawyers. And we worked very carefully with the organized bar, the Illinois State Bar, the Chicago Bar, and actually we had one meeting with those representatives and a representative of Avvo and LegalZoom we thought it was important to bring everyone to the table and talk through these situations.
So you raised two different issues there. One is access to justice. One is employment of lawyers. How is this an access to justice issue in your view?
Well, I view access to justice to be a term that applies more to those clients without means who are represented by legal assistance lawyers. I think the AVO and LegalZoom issue is more access to legal marketplace. And to me, and to those of us who gathered around and talked about this and looked at the facts, we believe that if we can facilitate or allow matching services to connect lawyers and those who have means, even at a moderate level, to hire lawyers, then those legal issues that go unmet today might have a better chance of being met. We were particularly taken by some of the advertisements by some of the matching services. They seemed to be really good at stimulating a marketplace reaction, showed lawyers as being helpful, competent problem solvers, and sent a message of solutions being possible. So that was part of our thinking as well.
I don't know if you were at the ABA Center for Professional Responsibility conference this past week. I was there, and this report was being talked about. And, lawyers seem to be sharply divided on this question of whether, even if this can enhance access to lawyers, whether it's the right way to enhance access to lawyers. I heard one lawyer in the audience refer to AVO Legal Services as just a kind of a glorified form of ambulance chasing. You've looked very closely at this in this report. What's your response to that?
Well, I was at the Louisville conference as well, and I heard that lawyer say that, and I don't believe that's accurate. We've had differences with LegalZoom or AVO over the years before this last study period, but I don't think that's the case at all. The real question, I think, was one discussed at some depth at the conference, is does allowing a matching service where a fee is earned by the matching service when a lawyer-client relationship is formed and the service completed in an amount that looks like it's a percentage or proportion of the legal fee, is that really the kind of fee split that needs to be prohibited? There are some very good discussions by people in the audience, and I really enjoyed listening to those comments. And of course, we all talked about the examples of the prepaid plans and the insurance defense model, where there is indeed some influence on a lawyer, but the rules recognize that those influences don't compromise independence. So the question is, for legal professional responsibility, is can and should the Supreme Court of Illinois permit the fee split that, as an example, the AVO Legal Services model provides?
Did I understand you to say that you don't see this report as taking a position or necessarily advocating for a position on this?
I think it's a lean into how this could work, and it certainly gets close, but we've not made a recommendation. At some point, after public comment, our Board of Governors, called our commission, will take all the information, decide what they would like to do with it, and they might make a recommendation to the Illinois Supreme Court.
Well, you have a section of the report in the appendix called Draft Framework Proposal, which kind of outlines what this rule could look like. That looks like a proposal, and it's called a proposal. What's the purpose of that? What is your thinking around that?
A framework so people could actually see what it would look like. And it would be fair to say there's a lean in the study, but it's not yet a proposal. We want to hear from all sides. We have had at our table the Illinois State Bar and the Chicago Bar, and we're going to speak with them more. We expect to reach out to AVO and LegalZoom and others and our Access to Justice folks here and spend the summer really hearing from people as to what they think and whether we can accomplish something here that serves the objectives I talked about at the front end of this conversation.
Yeah, it's a fascinating document, and I hope listeners to this program will take the time to read it. We'll be sure to include a link to it. With the notes for this show, I've written about it on my blog, Law Sites, with a link to it. It's on the ARDC website. 124-page report. Almost reads a little bit like a legal brief. I mean, you've really done your research here, and you talk about the issues broadly, the ones you've already outlined. You also talk about how other states and how the ABA has addressed this issue. And you talk as well about some of the other possible legal issues, the constitutional issues, antitrust issues. I have to say congratulations on this. Had to have been a lot of work just to put this together, and it's a fascinating read for anybody.
There's a lawyer in our office, a young lawyer out of Kent, a law school here, who has made it most of his last year of time working on that. But the important thing is I believe no matter what our court does and what we recommend to them, we can say to our Supreme Court that if it were to maintain the present rules, or to go in the direction of the framework, they would be on firm antitrust and constitutional law footing and could adopt a rule that would be pretty difficult to challenge.
Yeah. And I guess the other thing, and we talked about unmet legal needs, and the other aspect of this that you talked about addressing through this report is that of the underemployment of attorneys in Illinois. And of course, that's not just in Illinois. So again, how do you see what AVO is offering as potentially a solution for that issue of underemployment of attorneys? I
want to be broader than AVO. And they've spent a lot of time with Josh King from AVO and Jazz Rementhal from LegalZoom. But the ABA tells me there might be 400 services like this out there. And so we want to see whether, I guess the question is, can these services bring lawyers and clients together to provide more legal work for lawyers that's meaningful to people who today wouldn't even consider hiring a lawyer. Perhaps they don't see their issue as legal, don't see a lawyer as a problem solver, or don't think they can afford it. So our state bar did a great study on the unmet legal needs themselves. And I want to push back a little bit on your very fine writings. I don't think they're all demonstrating hypocrisy. They just see a core value in their view of Rule 5.4. But they have been at this issue of access to justice and access to marketplace and doing it in great good faith. And we will work with them. The Chicago Bar Foundation, not the Bar Association, but I suspect they're aligned, has taken a little different approach, and they would open up 5.4 to allow for the matching services. At least their proposal today would do that without any regulation of the matching services, or at least without any required regulation of the matching services.
Yeah, and I have to underscore that hypocrisy was my word and not yours, and not contained anywhere in that report. And when I wrote about the report, but it kind of sounds that way as you read the report, because you seem to be saying, the report seems to be saying that bar associations have not-for-profit matching services that function essentially the same way as the for-profit referral services do. Bar associations not only allow those nonprofit referral services to operate, but in fact, often they are operating them themselves. And in some cases, these might be the same bar associations that are issuing ethics opinions against the for-profit services. And when you focus on that fee issue, that question of is this fee sharing of some kind, it sounds a little hypocritical to me. So,
I hear you, but the one part of the analysis that permits those carve-outs to 5.4 that developed over time is one of your colleagues, our colleagues mentioned at a couple sessions in Louisville, is that bar associations are not-for-profit. More than that, they are part of the fabric of the profession, and in one sense are organizational officers of the court, and they lean heavily into access to justice. So you could certainly make that argument. I happen to believe in that argument, but I might also, you've picked up the lean of our study pretty well, Bob.
I thought it was also interesting, certainly to me, because I've talked and written about this in the past, that there's a section of the study titled Legal Profession's Resistance to Change. And the opening sentence of this section says, the legal profession's resistance to change impacts potential clients' access to the legal market and lawyers' access to new and innovative ways to reach clients. Why did you feel it was important to kind of address that?
Does it surprise you that lawyers generally and bar associations as populated by lawyer members have resistance to change?
Does it surprise me? Not at all, no.
No, it's just we're a precedent-based profession, and the rule of law is what drives us. So I think we have some difficulty in effectuating change, but I want to return to the thought that we got together LegalZoom, AVO, Chicago Bar, ISB, and others to have some really wonderful conversations that helped form this report.
Yeah, but you're in doing that, you're somewhat going against the grain. I mean, you cite in the report the example of the ABA partnering with Rocket Lawyer in 2015 in a pilot program in several states, including Illinois, and then almost just as quickly backing out of it again when it proved to be something that was not popular with the ABA members. So, I mean, it's a real problem that is institutionally ingrained in the legal profession, and it's something that really does stand in the way of progress.
There is a natural ingrained resistance among lawyers generally, and it's, I think, nationally true. It's not untrue here, but here, unlike any other state, people's eyes are open to consider what works in the best interest of the public. I don't want to say other states aren't thinking that way, but we happen to be the first to come out with, I think, a comprehensive study of this issue, of course, based upon access to justice studies done by the organized bar. I want to make sure we're balanced here.
Right. I want to get more into the report and the framework that you've outlined here, but we do need to take a quick commercial break. So why don't we do that now? And when we come back, we can talk a little bit more about the framework that you talk about in this report. So please stay with us. We will be right back. Imagine what you could do with an extra 8 hours per week. That's how much time legal professionals save with Clio, the world's leading practice management software. With intuitive time tracking, billing, and matter management, Clio streamlines everything you do to run your practice, from intake to invoice. Try Clio for free and get a 10% discount for your first 6 months when you sign up at their website, Clio.com, that's CLIO.com, with the code L2L10, that's L2L, the number 10. Welcome back to Lawyer. This is Bob Ambrogi, and today we are talking with Jerry Larkin, administrator of the Attorney Registration and Disciplinary Commission in Illinois, about a report that they have just issued on matching services and framework for perhaps making that more workable for consumers and for lawyers and for the professional responsibility community as well, I guess. So, Jerry, tell us what the framework is that you've kind of laid out here as a starting point for this conversation. How do you see this potentially working?
Well, I believe that at the highest level, the rules would be amended, 5.4 and the 7 Series rule amended, to allow Illinois lawyers, if this were adopted, recommended to the court and adopted by the court, to accept cases from a matching service that was registered with the ARDC. So there are 2 prongs to this, and would be in place certain restrictions to avoid compromise of independence. And on the other side, it would avoid us finding boiler room operations in the mix. The comment at the ABA conference in Louisville was, well, isn't this going to allow people to chase cases on the street? And this is one reason it wouldn't. There would be some bona fides to a matching service. It's not just Larkin boiler room operation in the basement of my house, employing runners to bring cases in.
So that registration is key to it, as you see it.
It is, and part of it might also be to, much like the bar associations do today, ask those matching services to step up with some resources to go towards the access to justice issue, as opposed to the access to legal marketplace opportunity. And I spoke with one of the matching services we've discussed earlier, and that representative said that would, of course, be something that would be in the discussion, and I sense the willingness to make that kind of commitment to the legal marketplace.
As you've outlined this in the report, the lawyer's payment to the service would be recognized as a percentage of the fee, or could be recognized as a percentage of the fee. And I thought that was interesting because there seems to be a great deal of acrobatics by some of these services and by the lawyers to define the payment as a marketing fee and to break it out as separate from the services. That sometimes feels artificial. It sometimes feels like contortionism. And it seems to make so much more sense to just call it what it is and give it the blessing of the rule.
That's exactly what we thought. And you could see that happening with the contingent fee permitted to a bar association referral organization. It wasn't in the rule to begin with. It happened. It was challenged in court in Illinois and elsewhere, and eventually it became permitted. I think it's better to be realistic with what the rules are, be clear, rather than resort to contortion.
A lot of lawyers who are going to hear about this are, again, going to throw up the argument that this is going to be bad for consumers and that these kinds of services can be bad for consumers. You're saying that by providing standards for the qualification and registration of these services, that you'll provide protections that otherwise wouldn't be there. Do you have a sense of what those qualifications would look like? How would you want to see a service such as this? What kind of protections for consumers would you expect would be necessary in order for a service to become qualified under this kind of a plan?
Well, I think that the service would have to show a bona fide presence in Illinois, a registered agent, some corporate or some business structure amenable to service here, service a process here. We would require a fee, an annual registration, and use our own disciplinary mechanism to address failures in the various standards we would, the framework talks about, which are really very few right now, might be more, but we watched the Florida model that was so far off of this, and we thought that our colleagues whom we love from Florida just had too many regulations in the proposal that went to the court initially, or the second proposal. So we learned from that. And really we would just, at this point, the framework would say no in-person solicitation, nothing false or misleading in terms of advertising, and we've added something that would accord privilege and confidentiality to the preliminary communications between the prospective client and the participating lawyer through the entity. And I don't know who else has thought of that, but we don't want, if this entity is not a lawyer, obviously, we don't want a question of privilege to later arise.
One of the other issues that were raised in Louisville that have been raised in a number of the ethics opinion is this concern that the arrangement between a lawyer and a service such as this could in some ways compromise the lawyer's independence of judgment in representing the client and in defining the scope of the representation and in setting fees and determining appropriate costs. What's your answer to that? How does this framework address those kinds of concerns?
I don't see anything in my framework right now, but it would have something that would generally prohibit such intrusion on independence. But what I enjoyed listening to in Louisville, which was on my mind anyway, is this doesn't seem any more risky than the prepaids, the very carefully crafted insurance defense model and other models where others than the client have some presence in a lawyer-client relationship. I'm confident we could figure out and assemble, if we go forward with this, any additional protections necessary. It does resolve another issue. It's not the only way to resolve it, but today, lawyers in Illinois, I suspect in other states, don't know what the rule is, or there's a lack of clarity. So we intend, by whatever happens at the end of this study, and whatever proposal will go to the court, I would imagine it would resolve ambiguity.
Yeah, I think that's important. I mean, it seems inevitable to me that the rules are going to move in this direction. Something else that I picked up on at the Louisville conference was a comment made that they weren't aware of any basically reported instances of a consumer being hurt in any way by using Avo Legal Services or any of the other services of that ilk. I don't know if that's your experience as well. I know I haven't heard of anything coming out of that.
That is our experience here. I am not aware of any grievance filed by a client who hired a lawyer through any of these matchmaking services.
Then the flip side of that is that there's again, it's something that came up at the Louisville conference, is that there are often times, or in many cases anyway, these limited scope representations turn into longer-term lawyer-client relationships, that these one-time instances of assistance lead to longer-term relationships, especially if it has to do with maybe starting a business or something like that. And I think that's something a lot of lawyers don't think about with these services. They think of them as these one-offs in limited scope situations, but that's often not the case.
We had the same thought. If it's a loss leader, I'm not sure it even is a loss leader, but it would just be that. It would be if a lawyer provides high-quality service to to a person forming a business, to use your example, there's a great chance that business person is going to pick up the phone next time and call that lawyer again.
So there have been several states that have issued ethics opinions coming down against lawyers participating in these services. Most often, they tend to focus on the fee-sharing concern. I know there have been a few efforts in the other direction as well. You've put this out for comment now, and I don't know whether you've started to get comments, but I'm sure you're getting a lot of reaction. What's the reaction that you're getting so far? What are you hearing from people about this report?
Well, we don't have many email comments yet. I thought the Louisville reaction, though, I think to the extent of someone wanting to open this up, that conference is preaching to the choir. And I got the reaction I got there, plus really good thought, was what I expected. I did a talk just an hour and a half ago on this topic to some lawyers. I didn't get a lot of reaction. They're absorbing it, and not even a handful of email comments at this point. But we do about 300 talks a year at ARDC, and we will include exposition of this topic at those talks in the next several months and see if we can't stimulate a reaction. And I will circle back, and we're going to be talking to bar leaders in Illinois and also to the matching service leaders and other access to justice organizations and complete this study and really understand as much as we can about all of the nuances to it.
And so what's the longer-term plan? You get the comments, you have these conversations, you talk to these different interest groups and entities. Will you be making a more formal recommendation at some point, or is that a matter of waiting and seeing how this all turns out?
A little waiting and seeing, but I would predict that after a comment period, which might be extended, we will bring this back to our board of directors, our commissioners, and likely have something definitive as to what is identified in that study right now and make some recommendation to our court. You saw, Bob, that the announcement of it was on our Supreme Court's website. So it's not unknown to those who govern the regulatory efforts here. And this is not purposeful, but we have found ourselves in Illinois to be willing to take some risks. We adapted the proactive regulatory model that came out of New South Wales in our first cycle of implementing that. And it goes back to what I said. We're here trying to help lawyers to serve clients more effectively. That's our touchstone.
There's a lot in this 124-page report that we haven't talked about. As I mentioned before, you've got whole sections on the constitutional issues, the antitrust issues. But just let me ask you before we wrap up, because we're running low on time, is there anything else that you really wanted to highlight or talk about with reference to this report while you have the floor here?
Not really. I think I touched just briefly at a high level on the constitutionality and antitrust issues, which I don't think are real issues given how we're addressing this. I think we've talked about the other issues as well. And we are in a mode now where we're looking to engage lawyers and matching services and consumers and everyone in Illinois to inform us.
Well, you've posted this to the ARDC website. You're accepting comments through August 31st, 2018. Comments can be sent to information@ardc.org. Is there anything else our listeners should know about that comment process or anything else with regard to responding to this report?
That's it. We've also spoken about it with our regulatory colleagues from across the country, so I would expect to hear something from them too. In terms of our website and our email, it's iardc.org is the website, and information@iardc.org is the common email address.
Great. Well, any last thoughts before we wrap up? Any final thoughts on this?
No, I appreciate the opportunity. I've read your articles on this topic. I appreciate the opportunity to chat with you today.
Well, I really appreciate your taking the time to do this and appreciate all the work that went into preparing this report. As I said at the outset, I really hope listeners will take the time to read through it. It's a good read, if nothing else, especially for anybody who's interested in this issue. You really lay it all out thoroughly and in detail and do a good job with it. And, all sides of it. It's a fair and balanced report. Does kind of take a position in my mind as I read it, and I think you suggest as much, but it lays out, I think, all of the issues in a fair way. Well, thanks a lot. We've been talking with Jerry Larkin, the administrator of the Attorney Registration and Disciplinary Commission in Illinois. Also want to just make a note, a special thanks to Jim Grogan, Deputy Administrator and Chief Counsel at the ARDC, for his assistance in getting this program set up. That brings us to the end of our program. If you like what you heard today, please rate us in Apple Podcasts. Also visit us at LegalTalkNetwork.com, where you can leave a comment on today's show and sign up for our newsletter. This is Bob Ambrogi on behalf of Craig Williams and all the good folks at the Legal Talk Network. Thanks for listening. Join us next time for another great legal topic. When you want legal, think lawyer to lawyer.
Thanks for listening to Lawyer, produced by the broadcast professionals at Legal Talk Network. Join J. Craig Williams and Robert Ambrogi for their next podcast covering the latest legal topic. Subscribe to the RSS feed on LegalTalkNetwork.com or in iTunes. The views expressed by the participants of this program are their own and do not represent the views of, nor are they endorsed by, Legal Talk Network, its officers, directors, employees, agents, representatives, shareholders, and subsidiaries. None of the content should be considered legal advice. As always, consult a lawyer.